Go ahead and get started. All right. Good morning, everyone. I am Jennifer Slattery. I know most of you. Um, Thanks for being with us this morning. I'm with the League of Cities and Towns, and we're excited today to have an expert speaker on PFAS issues, which we've all been talking about. John is here, John Gardella. He's a member of the law firm CMBG3 and a recognized thought leader on PFAS issues. He's the chair of their firm's PFAS environmental risk management and consulting practice groups. And um, he has been quoted in a variety of articles and was recognized by the National Law Review as a thought leader on PFAS issues in 2020 and 2021. Probably beyond that, but I don't have those details. So, John, welcome. Thank you for being here. And we look forward to learning some of your good information on PFAS. Thank you.
Okay. Well, thank you, Jennifer. I appreciate it, and I appreciate the opportunity very much. Good morning to everyone. As Jennifer said, I am an attorney, and I've been practicing environmental law for about 20 years now. But up until 6 years ago or so, actually at this point maybe 7 or 8, I had never even heard of PFAS. I'm sure that's true of many people, including ones on this call or this webinar. But today it's sort of consumed my practice. And I think as I told Jennifer on our kind of intro call, it's about 98 or 99% of what I do now for clients. So it's big, and it's not just, I'm in Boston. Our firm is also in Providence, Rhode Island, but I'm personally in Boston, and it's not an issue that just is local to Massachusetts or even Rhode Island. It's really nationally at this point, and so that it's at that point that we help clients on a national level with PFAS issues. So, what I wanted to do today, Jennifer mentioned that, there might be kind of a spectrum of knowledge bases on the webinar today, just in terms of knowledge about PFAS and what's going on. So this is kind of the roadmap for what I wanted to talk about today. I'm not going to spend a lot of time on the first 2 points really, because I know that many of you may know it already, and but I did want to do it just for those who may not have that foundational knowledge. And talking about the litigation history actually informs kind of where we are today and why there are so many regulations that are impacting potentially all of you on this call today. And then we'll talk about the federal regulations, where we stand with those, and the PFAS litigation generally and really nationally. So, and Jennifer, I assume questions at the end, right? Or not as we go?
Sure.
Okay. All right. For anyone who's not quite aware, or maybe just a refresher, PFAS are per and polyfluoral substances. There are, at this point, the EPA has recognized over 15,000 of them, which is quite a group of chemicals. But they've been around for decades, actually going on almost 100 years at this point. Well, we're coming up on 90. But, everything that was found originally to be very beneficial in terms of their properties, the water repellency, oil repellency, heat resistance, all those things you see on the slide, are the exact qualities that make them accumulate. And they accumulate both in the environment, once they get into our water, our land, whatever it may be, or the human body, where they tend to stay in our bloodstream for sometimes many years, although some of them, have a half-life, as we call it, of just a couple of weeks. So, that's really why they are called forever chemicals, is because they are just persistent. And once they get into something, whether it's a human or the environment, they tend to stay, and they're very difficult to get rid of. On the flip side, those same properties that you see listed on the screen are incredibly helpful and beneficial to industrial applications and for consumer goods. Um, I'm not a chemistry major by any means or a chemist, but these are the chemical structures of the two most common and the original PFAS types, PFOA, PFOS. And really, I just wanted to show this slide because you see here the C or the carbon atoms that are making up this chain. They are what make PFAS so strong because apparently when you bond carbon atoms one after the other, they become very difficult to break, which is why PFAS are difficult to destroy and get rid of. So you see sometimes in the news something called C8 chemicals. Well, C8 just refers to PFAS that have 8 carbons in their backbone, like the ones you see depicted on the screen. There are PFAS that have only 1 carbon, and I think I've seen PFAS at this point that go up to 22 carbons in their backbone. As you can imagine, you can attach various different other elements, like you see here on the screen, fluorine, oxygen, etc., to the carbons as well. And so there's not an infinite amount of variations that can be made, but again, there are over 15,000 at this point recognized by the EPA. So that's why there are so many, just simply because of all the variations that humans can create in the lab, which is where these were invented and created. Um, I like this slide just because it shows sort of an everyday depiction of what PFAS has been used for and how prevalent it is in our homes and our everyday life. I like to use the example of, most of us when we wake up in the morning, the first thing that we go is to go to our bathroom, take a shower, brush our teeth, floss, use the toilet, put on cosmetics, perhaps, whatever it may be. But each one of those things that I just mentioned, as you can see on the bottom picture there, have historically and even do to this day have PFAS in them. Our shampoo, our cosmetics, toilet paper, floss, the water that we shower with, everything. So it just goes to show, and this is a very good depiction of just how prevalent PFAS has been and continues to be to this day. It's really this slide, though, that I think most of you are interested in, probably, because this is a great depiction of just how um, vast the environmental sort of contamination issues with PFAS are. Now, in the upper left-hand corner, it does label that industrial facility as a PFAS manufacturing plant. It doesn't have to be. It could be really any industry that is using PFAS or has used PFAS, whether knowingly or not. And any industry that is making anything or doing anything is going to naturally have some sort of discharge into the environment, whether it's air emissions or water effluent or sending things to a landfill. And so over time, over the decades, that's how PFAS has really gotten into our environments. And this is a great depiction on the screen because it shows all of those different applications or avenues for PFAS contamination. So, as you follow the stream down here, I'm sure some of you are interested in water specifically or waste management. You see sort of wastewater utility, I'm sorry, waste management treatment plants and water utilities depicted here. So historically, up until very recently, right, as the PFAS has entered these systems, they've been treating and processing the water as needed for what they do and sending it right back out into the environment and into our homes in the case of drinking water, which has sort of cycled it through the environment. Now, of course, now there's a great push to install and have technology for filtration to get PFAS out of the water for this very reason. But the key point here is that for decades, this has been happening, not illegally and not with any sort of malice by any sort of entity whatsoever, but it has just been happening. And it's one of the biggest reasons why today there is litigation around PFAS. And we'll talk about that in a couple minutes. So, transitioning just quickly, again, I think this is interesting to note for maybe some of you, but also important to understand how we got to where we are today, litigation-wise. So, this sort of scenario that I mentioned on the screen here is depicted very well in this movie that's now famous if you're into PFAS matters, named Dark Waters. And it really all began in West Virginia in the late 1990s, where DuPont entered into an agreement with a local farmer whereby they would have rights to use part of his land as a landfill. Now, what they, did not disclose was that what they were doing in landfilling was PFAS waste. they were making PFAS at this local plant in Parkersburg, West Virginia, and they were dumping the waste on his property. So over time, leaching occurred. You know, it got into the groundwater, it was in the surface water, and when it rained or just naturally, it leached off the property and into the farmer's adjacent property. A stream ran through that property, and the PFAS contaminated that stream. Now, he only became aware of this when his cows started dying in droves, and since he was a cattle farmer, he relied quite heavily on cattle for his well-being and his livelihood. Um, so, you know, the only thing he knew, since no one knew what PFAS were outside of DuPont's walls, was that it must be the water they were drinking. It turned out he was correct. Um, and, you know, as part of this sort of litigation that happened, DuPont had to turn over certain documents, and they ended up turning over actually thousands of boxes of paper documents to the attorney for this farmer, thinking there's no way that he is ever going to go through these documents over a case like this. Well, they turned out to be wrong. The attorney spent close to 4 years going through these documents, pretty much dedicating his life to doing that and figuring out kind of what PFAS were, what they could do, and what DuPont had known about PFAS for many years. So once this, as I call it, the cow case settled, he turned around and filed a class action lawsuit in West Virginia, which is now probably very famous to most of you, for the citizens along the Ohio River Valley who had been either having contaminated land or drinking the water from the Ohio River that had been contaminated with PFAS because the DuPont facility sat really adjacent to or near the Ohio River, and they had been discharging PFAS waste into the river for decades. So the key takeaway here is that in 2004, an agreement was reached, as you see here, for $343 million to set up this medical monitoring program. And this was revolutionary at the time. What they wanted to do was, or what the plaintiff's attorney wanted to do, is sort of set up this a system whereby the people involved in the class action could have their blood tested, they could give medical histories, and epidemiologists could sit down and figure out whether PFOA that was in the water had any impacts on human health. So this was a gamble on many parts, because on all sides really, because on the plaintiff's side it could show nothing, and in that event the cases all by agreement would just simply be dismissed, and this lawsuit would go away, and we may never really have known much more about PFAS after this. I just don't know. On DuPont's side, they were banking on the fact that the citizens would not show up in sufficient numbers for there to be a true epidemiological study done. The attorney representing the plaintiffs was very clever. He used the settlement money in part to pay each individual around $400 or $500 to come and get their blood tested. And as you can imagine, in the early 2000s in the West Virginia Valley, where there's coal mining towns, $500 per person, especially even including children, if you have a family of 4 or 5, that's a lot of money just to get your blood drawn. And that's what happened. 70,000 people showed up, and they got enough people to sit through testing and medical history giving to reach certain conclusions. This is a very famous, I guess, pictorial. You may have seen it in the news. I see it all the time in litigation. But it really depicts the findings of the science panel from that study that I just mentioned. Now, I will note it took many, many years for them to reach their results. But you can see here in bold kind of the ones, the disease issues or human health effects issues that they felt there was some probable link between PFOA and that health impact. So kidney cancer, testicular cancer, liver damage, thyroid disease, increased cholesterol, and in vitro fertilization issues were the big six, so to speak. I do always caveat this with two things. First of all, this study was only with respect to PFOA, but what you will commonly see in the media or lawsuits is that PFAS was studied in this particular study, and these human health effects are caused by PFAS. That's not what this panel was doing, the science panel. They were only studying PFOA, which is very key differential point, especially in litigation. And the other thing that I want to mention is just that's a little more nuanced, but it's important to just keep in mind they were not studying causation. And you and I, even as laymen, have an understanding of what that means. Causes B. That's not what they were doing. They were not looking to see if PFOA causes kidney cancer or testicular cancer, for example. What they were looking at and what they made these determinations for is associations, which in a very layman sense way is just kind of observations of connections between A and B, but it doesn't necessarily mean causation. Now, an example I always like to give when I talk about this is, imagine a study that's done that says, we've noticed an increased risk of kidney cancer in people that don't wear seatbelts when they drive. Does that mean that not wearing a seatbelt causes kidney cancer? No, absolutely not, right? It's an association that's noticed, but it may have no meaning whatsoever. That's an extreme example. I'm not saying that the science study was finding things that were just inconsequential, but it is what they were finding, associations, sort of interesting observations. And they actually did note in their papers that more studies needed to be done to look at causation. So what happened after these findings is that the plaintiffs started going to trial one by one for the injuries against DuPont. And you see here kind of the amounts of the verdicts. You also note they are steadily increasing, which ultimately gave DuPont great concern. And in 2017, they settled the whole class for $670 million. This is really, at this point, for myself personally, when I first really paid attention to PFAS, and I think that's true probably for a lot of the world, because this is quite a significant settlement. So what happened after the settlement? Well, something began to happen in the litigation world that I suspect is impacting many of you on this webinar to this day. And that is the plaintiffs' attorneys across the nation looked around and decided, well, what other types of products use PFAS and which ones have like a very high amount of PFAS and are causing potentially great environmental pollution risks and things like that. And so they landed on AFFF, aqueous film forming foam. There are some facts on this slide about what AFFF is. I suspect that many of you have heard of AFFF or are quite familiar with it, especially in the context of fire department personnel maybe on this call, even water utilities who are dealing with the PFAS issue to this day. But it's important to note that AFFF started out as a military application, but by the 1970s, it was, as you see here, being used not just by the military, but by airports, fire stations across the country. So remember back to just a couple slides ago when I showed that kind of pictorial of the environmental pollution cycle. You can imagine that, especially starting with the vast prevalence of the use of AFFF back in the 70s, that basically for decades, AFFF has been getting into our land, our soil, our water, and again, has been going throughout our environment slowly over the decades, being generated or processed through wastewater management plants and water utilities and cycled back through into the environment and further dispersed downstream. So it's for this reason that AFFF received a lot of attention, just because of the massive amounts of it that were used, the high amount of PFAS that were historically in the product, and the great amount or the ease of environmental pollution with the use of the product. So quickly thereafter, numerous lawsuits began to be filed. You can see some of the statistics here. And there were so many lawsuits filed across the nation that they had to establish what's called a multi-district litigation docket, or an MDL. And really what that is, it's not unique to PFAS, but when you have litigation over a toxic or chemical that have so many cases filed with very similar issues at play, the court system in the country can choose to establish this MDL, whereby all the cases are filed before a single judge. And that's what happened here. Any case that involves an allegation of AFFF, whether it's a pollution claim or a personal injury claim, it will get sent, it gets filed in the state where the plaintiff resides, but then it is transferred to the South Carolina MDL. And this gentleman you see here on the screen, Judge Gergel, is the one that presides and has always presided over this PFAS AFFF MDL. Now at its peak, which was just last year, actually, there were over 20,000 cases pending on the docket. And you can see here what they were alleging, personal injury, environmental pollution, basically. The defendants, of course, are the PFAS manufacturers and the AFFF manufacturers and suppliers of sort of chemical mixtures to the AFFF manufacturers that contained PFAS. So those are really the targets. There are others, but those are the ones of greatest targeting and greatest concern. So one thing that was very interesting, I do represent a defendant in the MDL, but not a PFAS manufacturer. Really, it's more of a tangential player, truthfully. So I've followed this docket for quite some time, and one of the things that I found very interesting, which really hasn't happened before in any other type of MDL, or really, truthfully, in any other litigation context that I have seen in my career, is that sort of the players that or the entities that one might think might be at risk for being sued for environmental contamination issues actually went on the offensive and started filing lawsuits against the PFAS manufacturers and the AFFF manufacturers. So, for example, I remember way back in the day now, many years ago when this all began to percolate, the water utilities were incredibly concerned that they were going to be targeted by plaintiffs' attorneys because, they were thinking, well, we're the ones that have been taking in this water and not filtering out the PFAS. Again, they would have no reason to, but still, this is the way the litigation works in the US. And then we've sent it back downstream and arguably have further contaminated more land, more water, maybe even caused some harm to some people through their drinking water. That was their concern. So they said, well, we're not going to wait to be sued. We're going to turn around and file lawsuits against the PFAS manufacturers themselves and the AFFF manufacturers who have really caused these issues that we now have to deal with. And so what began to happen, the water utilities were the first ones to do it, but you see listed here some of the other types of entities, municipal entities that did the exact same thing. Wastewater operators, airports, even towns and cities, and states, including Rhode Island, which hopped on board, I think, 2 or 3 years ago with a lawsuit. And sort of interestingly, I included in here school districts. I did see a case out of Massachusetts here in which a school district sued the PFAS manufacturers and the AFFF manufacturers for PFAS contamination. Now, the facts in the school district scenario were a little bit unique, I think, because the Groton Dunstable School District actually has its own private water supply. They draw drinking water from some of the wells, private wells on its land, in order to be able to provide drinking water to the 600 or 700 students and teachers and others that are at the school on a daily basis. So that's a little bit unique. I have to candidly admit, I don't know if any other schools have that type of system. I imagine some do, but I don't know in Rhode Island if that is something that exists. But the point here is really that municipal entities have for many years been thinking offensively and not waiting to react to lawsuits that get filed against them. They've been much more proactive. And it's one of the reasons why initially there were so many cases on the docket. Today, the docket is really dominated by personal injury cases, firefighters that have been using the foam, or even sometimes their spouses who allege that they were exposed to PFAS from the firefighter bringing home PFAS on their body or their clothes. But there are still a significant number of these particular cases, like the ones you see depicted on the screen. It's difficult to give an exact number, even though I am involved in litigation, because of the number of cases that are dismissed and filed on a daily basis, really. But there are over 500 cases that I believe include municipal entities as the plaintiffs on this particular docket. Um, so, the litigation in the MDL began uh, with the water utilities. As the judge sort of famously said at this point, if the water utilities can't even prove their cases about PFAS and against the PFAS manufacturers, then I really doubt anyone else could. So that was his view, and he said, well, the water utilities are going to get first dibs and first right to litigate their cases. And that's what happened. And so in an MDL, what they do is they go through a long discovery phase and they end up choosing two, maybe three cases that they call bellwether cases. The purpose of a bellwether trial or bellwether case is to either get a settlement or go to verdict. And either way, you figure out whether the cases are defensible. So you get a defense verdict and the cases are worth nothing. Or, the water utility prevails and they get damages, 100 million, 50 million, whatever it might be. And you do two or three of these, and then the court likely would have paused and said, well, we're going to stop here. That should try and inform the parties now about potential settlement discussions because it gives you metrics and sort of signposts in terms of what the cases may be valued at. Well, we never got that far, as many of you probably know. In June of 2023, really literally on the eve of trial, this town in Florida, Stewart, was the first case up for trial, but on the eve of trial, the two biggest players, 3M and DuPont, settled. Now, the settlements that you see listed on the screen, which, total about 14 to $15 billion, I guess, on the high end. That was not just for Stewart. I heard somebody on the phone on the webinar before, I think, talking about water utilities and going through the settlement application process. So I know some of you are familiar with this, but what these companies did is set up funds basically, and you see the amounts right here, and water utilities that have tested their water for PFAS and have got detectable limits, or even water utilities that think that they might have PFAS in the water but haven't tested yet, can be eligible to apply to these settlement funds and get some sort of compensation to help them with remediation costs and technology, filtration technology, well, monitoring wells, whatever it might be, to help pay for some of that. Now, it was always understood, by the court, by the plaintiff's attorneys, even by the attorneys representing the water utilities and the companies that entered into the settlements, that these amounts of money here that you see on the screen, even at the high end, was nowhere near close enough to be able to provide each water utility that's impacted with the amount of money they would need in order to pay for any remediation technology that would be needed. I've seen various estimates. I think the ones that are most commonly published are ones that are sort of associations that represent water utility interests, and they often publish things in the range of 40 to $50 billion would be needed in total over the next few years to be able to comply with what are now federal regulations and to install needed water treatments technology. Now, that was a couple of years ago. I think, well, it was 2 years ago at this point that I saw those numbers coming out. I have since seen numbers that are a little bit higher than that, and they seem to be creeping up into the 50 to $60 billion range. So point being, it was always understood that any water utility sort of agreeing to these settlements or applying to these settlements, if they wish to, would not be getting dollar for dollar what they needed. And that's the nature of how sort of this litigation works. You're going to get pennies on the dollar, or maybe nickels or dimes or quarters on the dollar, whatever it may be, in terms of what you truly need, but it helps you get something here and now to be able to start what is necessary and what you need to do. So one of the questions that I have gotten on webinars like this at conferences, and in fact, I do represent a small water utility up here in Massachusetts. And the question is, well, if I'm only getting that amount of money, where am I going to get the rest of it from that I need to do what I need to do or to comply with what the federal government seems to be wanting me to do? And the answer, as an attorney, I always say, well, consult with your attorney. But the thing that I say that water utilities perhaps should be thinking about or talking to their counsel about is going on the offensive even further, right? So remember, they went on the offensive in the MDL, and now they're entitled to certain settlement proceeds potentially. But where are you going to get the rest from? Funding may cover some of it, but it's certainly not, grant money, I should say, is not going to cover it all. I would say, literally think upstream of where your water utility facility is. I mean, if you're going to target the PFAS manufacturers themselves for creating the PFAS, and then the foam manufacturers for using the foam that got into the waterways that you now have to deal with, what about the other industrial or companies that are upstream of you that have historically been using PFAS and putting PFAS effluent into the waterways that you now have to deal with? I think that's a very natural progression to think about in terms of going after parties that could potentially be responsible. There's, of course, diligence that would need to be done with that. And that's often something that we have to counsel on in terms of figuring out, well, who might actually be a responsible party. And I understand, litigation takes time, and it could cost money. But on the flip side, exploring that theory and possibly getting, if there are truly viable players upstream of your utility, exploring that option with counsel is something that you should think about. Um, because again, you may need more money than you're going to get from these settlements, and relatively soon if the EPA continues to do what it's doing right now. With that, excuse me. With that, it's a kind of a good segue to talk about not the so much of litigation, but now getting into the regulatory agency developments. And I really will focus truthfully only on the EPA here. I will candidly say that, there are regulations really in every state that go well beyond what the federal EPA is doing. Some may apply to certain entities on this call. A lot of them do not. But, it's always good to understand what is at play in your certain state. But it's really the federal government regulations that are at this point driving a lot of what you're probably concerned about. So we'll start here with the Safe Drinking Water Act, which regulates or gives the EPA the ability to regulate drinking water and to go after parties that have allegedly contaminated the drinking water sources. Now, the issue is that the EPA, the Safe Drinking Water Act, or the SWDA, as I call it, doesn't just allow the EPA to randomly, willy-nilly go after parties for any chemical that it wishes in drinking water sources. There has to be a long legislative process and then a sort of a EPA process internally and a public hearing process whereby they say that they want to regulate certain chemicals under SWDA. That's exactly what they were doing under the Biden administration, really from the get-go, in saying that they wanted to target PFAS or certain PFAS under the SWDA and set enforceable limits. Because it's those enforceable limits that allow the EPA to then turn around and go after polluters or potential polluters of the drinking water source and get them to pay for the costs for cleanup. Without that, without listing the chemicals officially under the act, the EPA can ask all they want for polluters to clean up the drinking water, but I think we all know that that's not realistic and is just not going to happen. So prior to April 2024, we'll get to April 2024 in a second, there was no enforceable limit. There was a 70 part per trillion advisory level, which is sort of what it sounds like. It's like a suggestion for anyone who wants to try and test their drinking water to see if there might be an issue or high levels of PFAS. But it has no enforceable teeth to it. The EPA can't do anything if you test your water and it shows 80 parts per trillion. Again, they can ask someone who they think is a polluter to clean it up, but they have no official power to go after them to force them to do it. April 2024 was huge, obviously, and many of you, I'm sure, followed this quite closely. So just a brief recap on the screen right here about what was said. The most critical is really the PFOA and PFOS limit of 4 parts per trillion. which, I remember the lead up to this. I was on call after call with clients or insurers or, even financial world people asking, what do you think the limit is going to be? And, I could have thrown a dart and picked a number. Where I often landed was 10, because I thought 10 was at the time very aggressive, and really sort of was at the boundaries of what was technologically possible to test for reliably. Well, the EPA disagreed with me for sure and went even lower. They went down to 4. And the only reason they set it at 4, and not 0, is because there isn't adequate technology, at least at the time, to test reliably for anything below 4 parts per trillion. You can see some statements that I highlighted here. Um, the key one is just the one that there's the last one, no safe dose below which either PFOA or PFOS is considered safe. That is signaling in the regulatory world to say that ideally they would have liked to set the limit at 0, which they would have had the power and authority to do. But again, the technological barrier existed. Either way, what they did establish was incredibly, seismic in terms of how it's impacting water utilities and others, even to this day. The second thing that the Biden administration which is, likely impacting municipal agents, is the Superfund law, also called CERCLA. Again, in order to regulate and go after polluters, for any chemical, you have to officially list it under the Superfund law first. And again, the EPA under the Biden administration went through that process extensively, and they listed PFOA and PFOS, which would enable them to go after polluters for really anything well beyond drinking water. We're talking about groundwater, surface water, soil, dirt, whatever it may be. They would have theoretically had the power to go after polluters to force them to pay. There were discussions under the Biden administration of expanding that list, but it never materialized, and so PFOA and PFOS were it. So what's the impact of just those two regulations? Um, I've seen numbers all over the map. There's no one number, right? I've seen insurance company projections. I think it was Lloyd's of London, project trillions of dollars in yearly cost to companies having to deal with, not just complying with the Circle and the Superfund issues, but remediating or cleaning up things so that they would not be targeted. I think probably a more reasonable measure perhaps is, some hundreds of billions of dollars, which is where a lot of the estimates land, in the $500 billion or more area. But again, either way you cut it, it's huge numbers, right? And it's important to note that those estimates are really only talking about PFOA, PFOS compliance costs. And again, at the time, there was great concern that the list was going to expand, but that has not materialized. Almost immediately, there were legal challenges to both of those regulations that I just mentioned. Those are actually still in existence today, but they've been stayed. Basically, when the Trump administration came into power in January again, they asked the court to stay the litigation because they wanted to reassess what the Biden administration had done and basically determine whether they would proceed along the same lines or change things, which could have impacted whether a lawsuit was even needed. So just a couple of weeks ago, the EPA actually did announce what it intends to do, at least with respect to drinking water. And this is really crucial. So I'll go back one slide because I didn't really focus on this, but you see these other chemicals with the 10 part per trillion limit. Well, Zeldin is the administrator of the EPA right now. The Zeldin administration under the EPA said, we're not going to, those are off the list. Okay. They were removed from regulatory rules for drinking water. I am not surprised by that at all. I thought that would be the case from the get-go. So that is really no surprise. What did surprise me was the PFOA and PFOS rule or regulation was going to stay. Well, that didn't surprise me. It would stay. I thought it would stay. I thought they were going to change the limit to something higher. And I actually thought they might go as high as 15. But what surprised me, and I think many other people, is that they said, no, it's going to stay and it's going to stay at 4. So that was quite a surprise. And, it sort of puts right back into the fire the issues that water utilities now have to deal with, and very quickly. Under the Biden administration, regulation, water utilities had until 2029 to come into compliance. The Zeldin administrator has said, well, we're going to push that to 2031. That hasn't officially passed yet. I suspect it will. But nevertheless, we've still got 5, 6 years of a compliance window, which isn't a huge amount of time, especially considering the point I just made about the costs that are going to be needed. So in thinking about the next 5 or 6 years, compliance with this regulation is huge, as is, again, finding alternate funding sources. And I will just note, uh, who knows what's going to happen after this Trump administration? Will it be Republican power again? Will it go back to Democrat? It's always possible that Democrats could come back into power and these could become even more aggressive than they are now. So it's really, really, really critical for really any entity impacted by these regulations to start planning now if you have not already, and figure out where you need to go. With respect to Superfund, that remains up in the air right now. Truthfully, they haven't said anything definitive. But there is what I think is going on in the background is this legislative push to create exemptions for the entities you see listed here, whereby basically, even if the PFOA and PFOS designation remain under Superfund, the EPA could not go after these entities for cleanup costs. What I always like to say, and I think that is what the push is, and then the EPA will say, well, the designations will stay, but we have this legislative carve out now, these exemptions, so we don't have to worry about the EPA going after these entities, these so-called passive receivers. But the issue, and I highlight this in yellow here, I always mention this to any of these entities, is that all that means is that the EPA can't go after them, right, for cleanup costs. That does nothing to preclude private parties or class action groups of citizens from going after these entities in civil litigation for cleanup costs or personal injury. And we'll talk about that in a second, but it's very, very important. This is not a broad sweeping get out of jail free card, so to speak, from litigation. It's just that the EPA will not be able to go after these entities. So with that, on the litigation note, we're going to turn to some non-MDL litigation trends in the US about PFAS. This is really where I spend a lot of my time right now with PFAS, and for good reason. As you can see, the number of class action lawsuits have increased enormously over the past few years. Um, and these are really just groups of citizens, whether there's hundreds, thousands, or tens of thousands of them, getting together and saying, well, our land has been contaminated, our drinking water has been contaminated, and we're concerned about our health. And so the companies that we're suing should pay for this. Um, that is what medical monitoring is. It's a claim that says, when we're not injured yet, but we think we might be, so you need to pay for our medical costs now to monitor that. And if we get something, you need to pay for our care and treatment. These lawsuits are entirely not reliant on federal regulations. So what I was saying before Trump came into power this time is, even if he were to wipe away every single regulation or regulatory thing that the EPA did under Biden and went off the books, that would do nothing to prevent any of these lawsuits from being filed, because they don't rely on the Superfund law or the Safe Drinking Water Act to bring their claims. Medical monitoring claims are very, very costly, and they are driving the litigation. On average, it costs about $17,000 per plaintiff to set up a monitoring program. So you can imagine, if you have a case, and these are common, where there are several thousand or 10,000 citizens or more banding together, you can do the math that could add up to a very hefty amount of money. The largest medical monitoring PFAS class action lawsuit right now has a certified class of 100,000 citizens down in North Carolina. So, I'm not even going to try and do the math on that, but it's an enormous number. So what I wanted to do now is just, I could pick out of the air hundreds of lawsuits, dozens of lawsuits for you to show you how this is playing out. But I wanted to show you some examples where, it's impacting, or municipal agents or entities of some kind are involved. And a good one here is the city of Savannah, Georgia. It actually went on the offensive again. It is the one bringing this lawsuit against, not just PFAS manufacturers, but look at that list. Look at that list of types of industries that have been sued. That is what I was talking about with the water utilities, where these entities are starting to look sort of upstream or at other potential sources of PFAS contamination and litigating against them. It's exactly what Savannah is doing in order to pay for the cost of cleaning up its drinking water citywide. So this is a perfect example of what actually is happening and what I've been talking to water utilities about, whether directly or indirectly, about what should be possibly considered to sort of get the costs that you would need. Now, this is an interesting one out of Connecticut. This is plaintiffs, a group of plaintiffs, class action lawsuit against two water utilities in Connecticut. And the theory here, and it was really the first one that was filed, but I've seen a few others pop up that say the same thing, is that the water utilities knowingly provided citizens with drinking water contaminated with PFAS. So you can see here what the damages are that they're looking for, but it goes to exactly the fear that the water utilities had before the MDL was even set up, that they might be targeted in litigation for a claim exactly like this. And this is playing out right now. It's taken many more years and is going well beyond AFFF. This has nothing to do with AFFF. It's just you were providing us with drinking water that had PFAS, and you should pay us damages. So. And then the last two I'll show are just kind of how these are impacting constituents within your towns, for example. This is an example of a company that unknowingly was using, or I'm sorry, it wasn't even using, it was taking in water from a local waterway and using it in its recycling process. It was therefore putting some of the residuals back into a landfill, and the water was going back into the environment. Well, they were sued. They were targeted, even though they never used PFAS, and they had no idea what PFAS were until they were sued. They were literally just using the water that had it in it. But now they're involved in an EPA enforcement action, a class action lawsuit, and two personal injury cancer cases have stemmed from this as well. So, other companies in your constituent area are also dealing with these things. This is another example out of Connecticut as well. This was a diaper and Kleenex manufacturing company. Just to show the scope of what plaintiffs are doing in this country, this is an air emissions case. Same types of theories, you put air emissions out at a PFAS in it, our property is devalued, our drinking water is destroyed, and we have a concern for risk of human health. So these are all incredibly costly lawsuits, and are just kind of show the scope of what's going on in the country. So to finish out today, I just thought maybe talk about some things to think about or tips for minimizing risk for municipal entities. And that's really the things that I show on the screen here. Whenever I'm talking to a water utility, or the times that I've had to talk to towns or fire departments about this type of thing, you have to understand the historical factors at play to you specifically. Because without that, you really have no grasp or no control over what your risk might be. And if you don't understand your risk, there's really no way to understand how to move forward. So, I understand records may not exist, but there are other ways to get the information that can give you a glimpse into historical, risk issues and even current and present day risk issues, which are a lot easier to obviously determine. So I put on here two things. First of all, I've mentioned it already today. Consider or discuss with somebody going on the offensive. How can you do that now? While it may in the short term cost you some money to do that, in the long run, it may give you the sort of not windfall, but the amount of money that you may need in order to comply with what is going to be required in this country, or to really just sort of minimize your future risk from being brought into lawsuits. And that's the second point. Be aware, as I just showed you several examples, that municipal entities are being brought into lawsuits and sued. So again, understanding the historical factors that may put you at risk for that is crucial. So fire departments really need, if you're not already doing this, I'm sure everybody really is, you need to consider AFFF substitutes, ones that don't have PFAS in it. Um, and you also need to understand, filtration feasibility studies. If you're, for example, a water utility. Um, I always say, a lot of people say, well, maybe we should just test and figure out what the risk is. And I hear that from water utilities and waste management. That is not necessarily always the answer. And in fact, it could open you up to reporting obligations that could increase your risk of litigation against you. So I always caution, if you're thinking about that, please discuss it with an attorney. That not only gives you protection of privilege and confidentiality, but it will further inform and guide you about whether that is really something that will help you, or whether it just gives you data that then you don't really know what to do with do something with, or opens you up to further risk. And then, consult with someone. I guess I put here consult with legal counsel, but it could be anyone. And figure out whether there are grants or settlement fund options and avenues that exist today that could help you defray some of the costs that are going to be needed for compliance in the years to come. And then again, I guess I'm really beating this horse to death, but considering litigation avenues where you go on the offensive. So thank you very much to Jennifer and everyone in the Rhode Island League. I really appreciate it. This is my information here if you wish to reach out, and I'm happy to answer any questions anyone might have. So,
Great. Thank you, John. If anybody has questions, feel free to either put those in the chat or you can just take yourself off mute.
I have a question. This is Deborah Jum.
Yep, go ahead, Deb.
Is there a statute of limitations for going on the offense? Specifically, there's the formal Navy base in Quonset. Obviously it's closed.
Right.
I honestly don't know if, I know we use their wastewater system, but I don't know the details of the water portion of it. But is there a statute of limitations for that? For the offensive, taking the offense for the town?
The answer is yes, in short, although it's not, defined by when the airbase or anyone
Right.
else used the PFAS or put it into the environment. It's really based on when you knew or should have known about whether you have a PFAS contamination issue.
Okay.
So it's very fact specific in terms of, and I'm sorry, Deborah, I don't know which entity or agency you're here on behalf of, but really just whenever that agency or entity um, knew that it had PFAS in its system, that would kind of be a logical trigger.
Okay.
And if you don't have that information, kind of when you may have reasonably suspected it. So it's typically 3 years to bring that type of lawsuit.
Okay. I don't know. There was just a question in general. I don't have the
Sure.
specifics of all of
Yeah.
the closure and that in front of me, but
Hmm.
just in general,
Absolutely.
those 3 years. Okay.
All right, anyone else?
No, I had a question on the feds with a different administration, but you answered that. How that would work.
Okay,
So
Great.
great. All right, well, hearing no other questions, we can go ahead and close this out. But again, thank you, John, for being with us. Folks, if you, I can circle John, recirculate John's notes, and we are recording this too, so you'll have the ability to share with your colleagues. All right. Thank you so much for another Workshop Wednesday, and have a great day.
Thank you, everyone. Bye now.
Yes, thank you, John.
Bye-bye.
Appreciate it.
thank you.